Americans are getting a crash course in the law just by watching what's unfolding in Minneapolis. And it is the law that may be dictating what's happening and what's going to happen next. So I think it's very important to discuss that because you have immigration law. That's number one. This is as ICE carries out a major enforcement operation with debate on how those rules are being applied, including a report that a 5-year-old and other children were caught up in an ICE operation while agents were trying to reach an adult. There's been some kind of mixed messaging there. We're going to talk about that. There's also constitutional law, specifically the Fourth Amendment. After an internal ICE memo reportedly surfaced asserting immigration officers can enter into homes without a warrant. And we're also seeing a lot of criminal law. A few ways. The Renee Good case, a woman shot and killed by a federal agent. An independent autopsy by her family says that she was hit 3 times, including a fatal shot to the head. Now, the government says it was self-defense. Does this complicate it? Her family says it deserves a criminal investigation. And then, anti-ICE protesters who allegedly interrupted a church service were charged under federal law. At the same time, a judge stepped in to protect a journalist covering it, Don Lemon. So you also have the First Amendment there, too. And then you add in federal versus state power and whether a state court judge can actually stop ICE from enforcing federal law. By the way, the president potentially invoking the Insurrection Act to send troops on the ground, maybe carrying out law enforcement duties. You see how the law is so important to understand what's going on there? It's kind of enough to make your head spin. I can understand that. But the good news is I got 2 great legal minds to join me. I got Mark Geragos, criminal defense attorney, and Peter Lichman, a retired Los Angeles Superior Court judge. Thank you both so much for coming on. Mark, I'll start with you. Let's start with the arrest for the church. So 3 people arrested, facing federal charges of conspiracy to interfere with someone's constitutional rights, right? The allegation is they went into the church, they interrupted somebody's ability to practice their religion, First Amendment. But is that countered? Is the counter argument, hey, we have a First Amendment right to protest? But again, it feels to me that a church, a house of worship, that would be different. Where do you stand on it?
Well, I don't know where I stand. I know where I think SCOTUS will rule if that issue ever gets to SCOTUS. And I will tell you, I think at the district court level, potentially at the circuit court level, if I'm prognosticating, I'm going to say that the right to protest does not end at the church door. And so I think this is a classic.
They can go in. They can go in and interrupt somebody. They legally, you think, would have the right to go in and interrupt somebody's worshiping, praying? I mean, they left the church. How is that possible?
I think the First Amendment does not, at least so far, it hasn't been ruled. Like I said, if this gets to SCOTUS, I could be singing a different tune.
All right.
But I'm telling you right now that the current law is, I do not think, FACE Act notwithstanding, because it hasn't been applied in this specific kind of a factual situation. But correct, I mean, it's a case of, we like, as lawyers like to say, a case of first impression.
Right.
As of right now, the current law is, I think they're good.
So, by the way, FACE Act is basically, using threats or intimidation to prevent somebody from practicing their religion. Peter, go to you. Do you agree with the judge's decision that Don Lemon, who's an independent journalist, shouldn't be charged here? So if we're talking about the First Amendment, is that what granted him protection here, covering that incident as a journalist?
I absolutely do. There's 2 procedures that they're going to follow. One was that they try to get a sign off by the magistrate judge. That didn't work. I personally think that he's absolutely right in his position. He's a journalist. He's observing. He's not doing anything, and he has First Amendment rights. I don't even know why every single thing that's being done by this administration is being federalized. This is just not acceptable. But now
where would it cross the line? Because there was reporting that Pam Bondi was not happy about this. There was reporting that the DOJ may be looking at a different way. Do you think there would be a situation where a journalist could cross the line in a situation like that?
Well, I'm trying to envision one, and I couldn't envision one because I have the image of Don Lemon just sitting there with a camera quietly recording. So, I mean, it's pretty hard for me to envision some line that he would cross that would not grant him the protection that he's entitled to as a journalist. They all recognize him as a journalist. I have no idea how this got even to the steps of a magistrate judge.
Well, I think it was grouped in. He was going. The impression was that he was there with them. There was, reporting. There was an allegation that he had been conversing with them, and so that's why he was caught up in this. But I want to move on. There's so many different parts of this, Mark. I have to talk to you about Renee Good. the shooting. So the feds say that it's self-defense, right? And that the evidence is that the officer was hit by her car. Comes out that a private autopsy that was conducted by the family concluded there were 3 shots, 1 to her head. Now, I'm curious how you think that affects the analysis, and I see it as 2 ways, right? Some would say excessive. Did you really need to fire that many? The other way of looking at it is use of force experts would say you fire until the threat is neutralized. But given these new findings, if they are accurate, if they're true, 1 to the head and 3 shots, how does it affect the analysis in your mind?
Look, I have both defended these situations. I have prosecuted in the sense of brought civil rights cases in these cases. It always comes down to a battle of the use of force experts. You're going to always have a police practices expert who's going to give the opinion that you just articulated a little bit more forcefully, that 3 shots is nothing. I've had cases where there's been 22 shots for somebody who literally most people would think was doing nothing. I've also had cases where I've taken it to a jury where there's only been 3 shots and juries have held the officer and the police departments liable based upon that. You know, one of the problems with these cases is that there's always the same kind of defense and the same expert opinion that is given, and it becomes a little tiresome. Anybody who's watched that video, I think, would have a strong opinion depending on what the prism is through which you're looking. I mean, it's almost like picking a jury. You're never going to settle this argument. There isn't going to be a way that you're going to convince somebody who thinks that was a threat that it wasn't a threat, and you're never going to convince anybody who looks at that and says, oh my God, they never had to do this. You're not going to turn them around. You take a look at those videos, the prism through which you look at it is going to determine exactly where you fall in this case.
It always becomes what's reasonable. What's reasonable under the circumstances, and a lot of times it will be up to the defendant, if this ever becomes a criminal case, the defendant take the stand and explain. Peter, I have to ask you about this news of an ICE memo saying that agents are allowed to use force to go into a home based only on an administrative warrant. So this is the final order of removal. There will be no judge involved. Obviously, this is different than our classic understanding of needing a judge's warrant. What do you think about that? Because the argument from Homeland Security, a spokesperson, would be these people already had their due process.
Yeah, I think that's going to be a very tough argument. And I've been waiting for this to be brought up. I've been waiting literally 6-7 months for this issue to come to a head, because the issue has always been, if there's a knock on the door, you have a right to say, hey, okay, do you have a warrant? And the answer should be yes, okay. Then if you have a warrant, especially with ICE now, is it an administrative warrant, in which case, have a nice day, goodbye, turn around and leave, or do you have a signed off Article 3 judge warrant? If you have that, you got a search warrant, open the door and let them in. I think the courts have to back up the fact that you just can't have administrative warrants having the same force and effect as a judicially signed. That's a check and balance that's built right into the Constitution. That's why it's needed as a protection for the Fourth Amendment. So I think this has to be brought to a head. I think somebody's going to have to say, they knocked in my door. I told them that I will not open the door. I will not allow them in. And I think it's got to be brought before a judge. And I think there has to be some kind of judicial review of this thing.
And just to be clear, this was an internal memo that was obtained by the Associated Press and is now part of the conversation. Mark, before I go, I have to ask you, there were reports about a 5-year-old being detained during an ICE operation, even though he wasn't the target. The administration has come forward and says that it was the father who was the target. He wasn't detained. They didn't want to leave him out in the cold. You do have to wonder what due process, what constitutional issues does that raise, aside from the court of public opinion. There's an allegation that the child was used as bait. Again, the DHS says the child was abandoned. There's a difference. Your thoughts on that?
Well, look, to follow up first on what Judge Lichman just said, he's right. This is the cornerstone of the Fourth Amendment is no more writs of attainder. And that, any way you interpret it, exactly what was articulated in that memo is precisely why we have a Fourth Amendment. That was the whole fight, basically, of the colonies. Sure. And so that, if that is the case, And
Right.
then you go kind of down this
what about the
slippery
5-year-old?
slope
What about
of
the
taking
5-year-old?
five-year-olds. That's
Yeah.
what I'm saying. If you go to the 5-year-olds, no, I don't think that holds up unless the Fourth Amendment is rewritten. If the Fourth Amendment is rewritten, and by the way, there is historical precedent for that. I mean, take a look at the second. If the Fourth Amendment is rejiggered so that you get to the point now where the very basis for the Fourth Amendment has been read out of existence, then I think anything goes.
Well, I think there still is a dispute on the facts about what happened here, but obviously we had to address it. We're not getting the answers right now, but clearly you've laid out the legal issues, and that may be seen by a court one day, and maybe, gentlemen, we'll have this conversation again. Really appreciate you both coming on, and thank you. Mark Geragos, Peter Lichman, thank you so much.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.